Good evening, everyone. It being 7 o'clock and a quorum present, I'm going to call this meeting of the Plymouth Planning Board for October 8th to order. Pursuant to Chapter 2 of the Acts of 2025, an act extending certain COVID-19 measures adopted during the state of emergency and signed into law on March 28th, 2025, this meeting will be conducted via remote and in-person participation. Members of the public who wish to participate in the meeting may do so either in person or via the Zoom meeting application. Information for joining can be found on the town's website. First on our agenda this evening are administrative notes, and we have minutes from August 27 of 2025. Do I have any questions, comments, corrections from members of the board?
Mr. Chairman, in the minutes for the Resnick Road Map Academy, it's stated that the proponents said they had already gone before the Conservation Commission. I interpret that to mean that they had had their meeting, and that, as my understanding, that had not taken place, in which case that's incorrect in the minutes.
Well, is that an incorrect statement in the minutes, or was that an incorrect statement made by someone?
I would have assumed, because the meeting came a few weeks later, that the representatives of the owner would not have made that statement, that they had gone before, unless their wording was such that it was they were understanding it to be that they had filed. I'm not sure, but I just thought I would note that because it said, I believe, that they had already gone before CONSCOM, which...
Okay, I think we should probably correct that then to say that they were going to go to the Conservation Commission rather than they had already gone. Can we make that correction? Very good. With that correction, any other questions, comments? Seeing none, I'll entertain a motion.
Move to accept the minutes as amended.
I have a motion. Do I have a second?
Second.
Any discussion? Seeing none, I'll call for a vote.
If I could, so Carl says he's on. I don't see his name here.
Can we,
Maybe Carl's here as under a different name?
can we at least get a visual as to who's on the screen, please?
So I disabled, I said that you could,
No, we have a presentation up on the screen right now.
yeah. So it's local scene, if you can show the people on. So are you under a different name? Are you in? I don't see you here.
Okay, we'll try and deal with our technical difficulties.
So 29, let's see here, 504151. And you got the 92943653363. A bunch of other people are on. You got it? Okay, great. All right. Yes. Is it because of that cord that's unplugged? So Carl's on now.
There we go.
Bravo.
What will we do without you? Very good. Okay, we have a motion, second. No further discussion. I will call for the vote. Mr. Donaldson, on the minutes from August the 27th.
Okay.
Yes. No,
Mr.
no issues. I vote yes to accept.
Thank you. Mr. Mand?
Yes.
Mr. Grandy?
Abstain.
Mr. Bennett?
Yes.
And myself, yes. Next on our agenda, we have a public hearing continued from July 23rd, 2025, and September 24, 2025. B 535-37 Sleepy Hollow Drive.
Mr. Chairman, I recuse myself from this hearing.
Thank you, Mr. Bennett. Let me read the public hearing notification. The Plymouth Planning Board will hold a public hearing in the 1820 Courtroom, 26 Court Street, Plymouth, Massachusetts, on Wednesday, October 8, 2025, at 7:05 p.m. to hear the petition of Teal Tree Farm
So,
Family...
Steve, so that's the next one, so this
Oh.
is an already open.
Oh, this is an already open hearing? I apologize. Very good. We will, so we have, this hearing is already open. We'll continue the hearing. Good evening, counsel.
Hi, good evening, Mr. Chairman. For the record, Rob D'Ambroso, attorney at D'Ambroso Law here in Plymouth. So I'm here tonight on behalf of the Sawyers. I think we all know, I think most of the people are probably here, some of these people are here for this matter, and again, this pertains to that 1978 Planning Board vote that included a proposed condition that, again, in my view, was never implemented, but, you know, we don't need to necessarily get into that, relative to lot division off of the last 50-foot section of Sleepy Hollow Drive, which was never improved, but is laid out on the definitive subdivision plan that's been of record for almost 50 years. So just to recap for everyone's benefit, we filed an A&R application on April 7th, I'm sorry, on May 7th, and we had our initial planning board here May 14th. At that time, I think the board's pleasure was, well, you heard my case, which I won't rehash, as to why it was appropriate to endorse the plan. Decided to push this out to allow notice to go out to all the abutters so that they could have an opportunity to, I guess, weigh in or be aware of the proceedings relative to that vote, which again was disclosed on April 14th, or May 14th rather, I'm sorry. So then that led to the July 23rd Planning Board meeting, and again, we didn't have much of a meeting at that time because I think the neighbors weren't willing, or at least the spokesperson of the neighbors weren't willing to express their concerns, said, well, you know, this is the first we've had a chance to hear in a public setting what you're proposing, so we'll react in due course. So then we continued. You know, I guess since then, there's been some outreach and communication with the neighbors. I can kind of go through that chapter and verse, and I imagine some of these neighbors or people on the roadway or whoever else is of interest here might have something to say, but I guess I'll shelve that for now in the interest of just moving forward. What we're willing to do and presenting to you tonight is, even though we actually now, in a sense, this whole thing could be considered moot because we've actually found the 2012 endorsed A&R plan. So we've got a 4-lot plan that's endorsed, that's suitable for recording. They don't expire. So we could walk down to the registry of deeds tomorrow and create those 4 lots. But again, we've got that condition out there, and we want to be sure that everyone's comfortable. So what we're willing to do, what my client's willing to do tonight is, if the planning board sees fit, we're happy to accept a revision to that 1978 vote, the specific condition specifically to reduce, or I guess allow 3 lots. Right now it says no division of the unimproved way. We obviously have the 4-lot plan that's ready to go. We're willing to tweak that language to allow 3 lots. We're further willing to accept, again, to make sure that the development of that area, the 3 lots, if we get 3 lots, is, you know, consistent with good planning practices. We're willing to submit that to site plan review for this planning board to have a look at the type of development we have there. Again, we typically, site plan review by the planning board would pertain to access, landscaping, screening, et cetera. So we're willing to do that if the board sees fit. And again, I get off my soapbox, I can talk about some outreach efforts, but hopefully that's all moot if the board is interested in going in that direction. And I'm sure you're going to want to hear from some of the people here too, so I'll get off my soapbox. Thank you.
Thank you, Mr. D'Ambrosio. To staff.
So again, just to kind of review where we are, we had a 1978 vote that said that that portion of the road, the layout, could not be used for frontage without improvements, and that a covenant would go on record stating such. So the vote, that was the vote doesn't get recorded anywhere. The covenant was never created, so there was no way to give notice that there was that condition out there. There was a 2012 A&R plan that was submitted, and at the time, nobody was aware of that condition. The planning board signed that plan that said that each of these lots had the required frontage and were on a road that was of adequate for frontage, and signed that A&R plan. So it's not a, it's a very unfortunate set of circumstances that happened here. I think it's not really clear. For me, when I look at that vote, it says that, it doesn't say you can never use that for frontage. It says you can't use it without improving. What was proposed on the A&R plan was a common driveway, so the frontage would never actually be needed to create access to those lots. It would just be a common driveway. I would point out too, I just did some looking, this is about a 4.3 acre piece of property. If you look at the R25 zone that it's in, that would be suitable for 6 lots, maybe 7. So if you looked at somebody extending a subdivision road down here, it could certainly be more than the 3 that's being proposed. The average lot size in this neighborhood is 33,000 square feet. That would equate to about 5 lots if you said, let's look at what's reasonable for the neighborhood, and what the average lot size is in the neighborhood is 33,000 square feet, which would be 5 units. So again, the proposal here is for 3. I think given the cloudiness of what we have here for documentation, that an A&R plan was signed, that there was a condition, but that condition was never fully executed, I think splitting the difference with an A&R plan that would come back to this board, having you look at buffering, site setbacks, lot layout to minimize any kind of view from abutters is probably a good compromise that will make nobody happy, but resolve the issue so we can move forward. Thank you.
Thank you, Mr. Hartman. Okay, at this time, I'm going to open up the public comment. Per the Planning Board's published public comment policy, everyone gets 3 minutes to speak. If you need more time, that is at the discretion of the board. The board can grant that by a vote. If it chooses to do so, we'll grant 1 extension at most. That's it, for another 2 minutes. So please keep your comments on point. I don't want to, again, limit anyone in terms of what they have to say, but also try, if you want to come up and speak, try and not be repetitive of somebody before you. After we've heard the same thing over and over, we'll let you know. We get the message, and we would like to move on to make sure that everybody who has a different point does get a chance to speak. So at this point, in the room, who would like to speak? Please come up.
Hi, my name is Shannon Sorensen. I live at 16 Sleepy Hollow Drive. I've lived here since 2014. My husband and I are raising our 3 children there and are very invested in this neighborhood. My husband grew up at 23 Sleepy Hollow Drive, where his father, brother, and niece live. And I'm going to read part of a statement that was prepared by the neighborhood collectively. So I'm speaking on behalf of many of our residents here, and I'm going to get through as much as I can, and I'm going to pass to the next. So we are asking the Town of Plymouth Planning Board the following: to follow and abide by the laws of the Commonwealth of Massachusetts, to follow and abide by the bylaws of the Town of Plymouth, Massachusetts, and to take into consideration documentation submitted in the past and opinions made by and to the Town of Plymouth when considering the application for subdivision as it pertains to 37 Sleepy Hollow Drive. To take into consideration any decisions or approvals made by the planning board in the past that may contradict the laws of the Commonwealth of Massachusetts, the bylaws of the Town of Plymouth, and adhere to the original subdivision agreement approved by the town in 1978. On July 5th, 1978, Sandra Burton, planning aide for the Plymouth Planning Board, sent a letter to Andrew Colas, town clerk, regarding the vote of the planning board held on June 28th, 1978, to approve the subdivision plan and profiles dated May 9th, 1978, with respect to lots 39 and 40 of Plymouth Assessor's Plot, which is now Sleepy Hollow Drive. In that letter, the sixth point or condition states, quote, indicate a 50-foot subdivision road layout over the right-of-way to the park. The board will grant a waiver of construction requirements on this portion of the road and covenant with the developers that no lots fronting on this portion of the layout with construction waivers will be further subdivided. And that is why we're here tonight. The 1978 map and subdivision agreement that was approved in June of 1978 and endorsed by the planning board in September of 78 shows one parcel of land for 37 Sleepy Hollow Drive, designated on that map as Lot 39-16. Tonight's hearing is about having this condition waived for parcels 100-000-039-039 and -040. With this condition from the 1978 approval indicated that no lots could be further subdivided, was a waiver granted in FY10 to subdivide lots 3916 into 39 and 3940. There is notation on the Town of Plymouth Assessor's card for lot 3940 in the comment section that indicates that it was divided into 3939 and 3940. Was that 1978 approval letter for the subdivision ever amended to reflect this change regarding subdivisions of lot 3916 to lots 3939 and 3940? If not, does that mean that these two lots are unbuildable? We're asking the planning board to not eliminate this condition based on the following 5 reasons. In 1984, the Town of Plymouth Engineering Division conducted a review of the plan submitted by the applicant. In that review, Frederick Smith, town engineer, indicated the following. The existing roadway that connects Sleepy Hollow Drive to the gravel road that runs along the perimeter of Morton Park is no more than a cart path. It appears that allowable frontage is being asked on what is commonly referred to as a paper street. Based on the Town of Plymouth Engineering Division pointing this out, how could or can the planning board endorse or approve an A&R in which frontage for a subdivision is being based partly on a paper street? In 2012, it was pointed out to the Plymouth Planning Board
Just to let you know, you're at 4 minutes now. So
I'm at 4 minutes
I'm
already.
going to give you a little additional time because you're speaking for a group, so I'll grant that.
Thank you.
But
I'm getting there. I'm getting there. I'll finish this bullet point and then I will pass it off. Thank you for that.
Okay.
Okay. So in 2012, it was pointed out to the Plymouth Planning Board regarding the subdivision request of 4 lots that under the rules governing A&R, Sleepy Hollow does not have a legally defined cul-de-sac. How would I stop there? And that's point number 2.
Good evening.
Good evening.
My name is Neil Corsa. I live at 31 Sleepy Hollow Drive, and I will continue the reading. So Sleepy Hollow Drive does not have a legally defined cul-de-sac. Using the 60% width for an R25 medium lot residential, according to Article 5, Section 205-4 of the zoning bylaws of the Town of Plymouth, is not an appropriate calculation that needs to be used in this case. Using the appropriate width, 80% of 110 feet, leaves a minimum required width of 88 feet. Lot 39 to 43 contains substantially less than is required of the width of 88 feet. Yet this was not done. Lots 39 to 43, 39 to 44 and a portion of lots 39 to 42 contain illusory frontage. This is based on the A&R handbook dated September 2012, which provides a clear and consistent guidance on the issue. These lots fail to show that they have safe and adequate access from the way along the lot frontage to the buildable portions of the lot. This makes the frontage illusory, and therefore the 81P approved A&R should not have been provided. Access through the existing easement of Moreton Park appears to fail in resolving this issue, and was not pointed out in the 1984 Town of Plymouth Engineering Division review pointed out earlier. Point number 3. Does the proposed common driveway meet the Massachusetts A&R requirements for the direct ingress and rapid response and Town of Plymouth turnaround and clearing requirements for emergency response vehicles, and who will be responsible for maintaining that common driveway, especially when snow or ice need to be removed? Based on the drawings provided for the A&R, it's not clear if the width of the common driveway as planned is sufficient to allow for the emergency response vehicle to pass another, and if this is indeed the case, would this prevent unimpeded entry and swift exit from lots 39 to 41, 39 to 42, 39 to 43, and 39 to 44, as dictated by the Massachusetts A&R requirements? If so, would the Town of Plymouth be liable for delay in rendering aid as a result? If the width of the common driveway as proposed is not sufficient for unimpeded entry and swift exit from lots 39 to 41, 39 to 42, 39 to 43, and 39 to 44, or a turnaround and clearing requirement for emergency vehicles, would the planning board require a secondary egress or access route? Under the plan for the A&R, it does show a gravel drive as means for the secondary egress, which passes through lots 39 to 41 and 39 to 42. However,
You're at 3 minutes, just to let you know.
may I continue?
Briefly, please.
However, this gravel driveway has only been accessed by going through lots 39 to 15, which is owned by Linda Silver. Does the planning board have the authority to grant a developer and the right to utilize property owned by an abutter in order to fulfill a secondary egress requirement if dictated by A&R for subdivision? If this gravel drive is secondary egress and need to be an emergency but impassable as a result of conditions such as heavy or snow or ice, who is liable in the event of impeded entry and the prevention of a swift exit to lots 39 to 41, 39 to 42, 39 to 43, and 39 to 44? Would the owners of lots 39 to 41 and 39 to 42 be required to maintain the accessibility of that secondary egress at all times, or would a separate homeowners association for those 4 lots need to be created, which would be responsible for the maintenance of the common driveway and secondary egress, including snow removal and emergency access? I will yield.
Thank you.
Gregory Pulichowski, 21 CP Hall resident. And number 4 on this little documentation, in the easement deed received and recorded on August 26, 1980, and found in the book 4868, pages 301 and 302 in the Town of Plymouth Registrar's Office, it represents an easement to Billington C, based on a plan titled Plan of Land in Plymouth, Massachusetts, prepared for Michael C. Sawyer, scale 1 inch to 40 feet, October 16th, 1979, revised November 7th, 1979. Associated Engineers of Plymouth, Inc., 85 Samoset Street, Plymouth, Mass. Registered professional engineers, in which it lists the following limitations. 3, the granted use of this easement shall be limited to the owners of lots 39-1 to 39-15 inclusive, and lots 39 to 17 and 39 to 33 inclusive, and their guests, their family, and their family's guests. The granted use of this easement shall be for recreational purposes only, and the easement area shall at all times be kept free of debris and motor vehicles. In order for this easement to be waived, every lot owner on Sleepy Hollow would have to agree to sign away their rights to this easement, which is part of every lot owner's deed. based on the A&R that was submitted. There is a concern by owners of the lots on Sleepy Hollow Drive with regard to how the details of this easement to Billington C will be conveyed to and honored by potential buyers of lots 39 to 41, 39, 42, 39, 43, and 39, 44. As this affects their titles based on the easement, ensuring that all owners of Sleepy Hollow Drive now and in the future will continue to have access to Billington C for recreational purposes. 5, it has been stated by counsel for the applicant that the A&R is already approved and that this is more of a courtesy at this point. It was also stated that the Mylar that was submitted to the town of Plymouth for the A&R on record is alleged to have gone missing once it was provided to the town of Plymouth for recording. There is a precedent in Massachusetts regarding time limits for A&R, specifically no substantial construction has commenced within 2 years of the approval. The approval will lapse and a new application, fees, and a public hearing will be required. Between the Mylar being lost and it being more than 2 years since the A&R was approved and not acted upon, is there really an approved A&R at this point, or does the applicant need to start the process over from the beginning? Based on the 5 points just presented, we believe it is in the best interest of current and future Sleepy Hollow residents of the planning board to not waive the no subdivision condition for this request. Thank you, gentlemen, for
Thank you.
hearing us tonight. Appreciate it.
Anyone else in the room wishing to be heard?
Hi, Linda Silva, 33 Sleepy Hollow Drive. The abutter to the right facing the property in question. There's some question in regard to the condition of the 1978 agreement indicating that Town of Plymouth wasn't recorded as part of the covenant, therefore it's not enforceable. It's part of the town record, therefore it's technically recorded. Mr. Sawyer was the original developer acquiring approvals and owner of the subdivision, had to have legally been notified because he was part of the entire process and was aware of the covenant. The developer legally cannot benefit from not recording a covenant that would negatively impact himself. In fact, I have a letter here from the Planning Board, October 24th, 1979, to Mr. Andrew Colas, Town Clerk, stating that they wanted to receive a reduced escrow amount. At the bottom, it was all prior conditions of approval shall remain in full force in effect. Copies were sent to not only the Planning Board, but Sawyer and Malone Enterprises and Rockland Trust, showing that he was well aware of the covenants in place. Also, when the development was made, it was a dead-end street. It was never intended to be a cul-de-sac. On this recording here, it says temporary turnaround. It was never done. It was never corrected. It was left like that. I have an assessor's map here at 100 that the town shows that it's a street, a dead-end street in which they built all the people on the street according to this. No cul-de-sac shown at all. Also, on the cul-de-sac or the temporary turnaround, it's half my property. My property extends out to the street that was originally approved by the Planning Board in 1978. This situation has been brought in front of the board before, and it was voted at that time not to eliminate the condition. And I happen to agree with it. I don't know what the changes are right now that would persuade you from changing your mind. Also, as they explained before, there isn't enough frontage on his property because there's an easement that we're all entitled to use. It's on our registry. On my deed, it does not state that there's an easement to use the turnaround. I've looked at it. It's based on what the assessor's map shows, a dead-end street. Thank you.
Thank you. Anyone else in the room wishing to be heard? Seeing no one, I'll go to Zoom. Anyone on Zoom wishing to be heard on this matter?
If you'd like to be heard on Zoom, raise your virtual hand. I'm not seeing anyone.
Okay. Seeing no one, at this point, I'll entertain a motion to close the public comment.
So made.
I have a motion to close public comment. Do I have a second?
Second.
I have a motion and a second. Discussion? Hearing none, I'll call the roll. Mr. Donaldson?
Yes.
Mr. Mand?
Yes.
Mr. Grandy?
Yes.
Myself, yes. So at this point, public comment is closed. Thank you all for giving us your statements and your opinions. Now's the time for us to do our deliberations. So I'm going to ask again, as I ask many times when people come, I appreciate you're going to start hearing things, you're going to start hearing our questions, you're going to want to speak again. That's not how this works. This is our time to deliberate. We will be asking questions of the applicant, we'll be asking questions of our staff, but this is our time to make our determinations. So please we've respected your time, please do the same for us. Thank you. At this time, I'll bring it back to the board as well as to whether or not we have questions for staff and for the applicant. I know I have some, so I'll reserve obviously to that, but we'll move along that way. We'll start, Mr. Donaldson.
Just, I guess my questions to staff in regards to statutes of limitations on some of the issues that were brought up by the, by the citizens. So in regards to the turnaround, as it being temporary, is there a statute of limitation on that?
So I wouldn't be able to answer that. I know that there is a recorded easement. It says temporary. It's there. It's existing today. Why it says temporary, I don't know, but I could not answer that.
Okay, and now my next question is whether it's staff or the applicant, has anyone actually seen the easement deeds in regards to what was presented to us today?
I'll confess, I'm not sure what easement's being referred to, if someone could
So
indicate that to me.
If I could, I think one of the comments was there is an easement for the neighborhood to be able to pass and repass for access. I do not, and it would be a question for council, I do not believe that prohibits the property owner who actually owns the property from passing and repassing too. So for example, if there was a driveway, one's not proposed in that area, but if there was a driveway, that doesn't prohibit the other people from passing and repassing. It wouldn't be a prohibition on any use of that property by the owner. They certainly couldn't do something that would impede access, but a driveway wouldn't do that.
Yeah, no, I mean, you can't frustrate the purpose of an access, so, of an easement, rather. So to Lee's point, if there's an access for easement, you can't do something as the landowner whose property is encumbered by that easement that would inhibit the use and intent of that easement. So you can't put a Jersey barrier across the easement, you can't put a big house in the middle of that easement that would prevent people from passing. But again, you could put a driveway. I'm not sure that's relevant at the moment, but you could clear that area, for instance, cut trees. That wouldn't probably improve access, but I'm not sure if that answers the question. But
I believe the easement that's referred to is there's an easement, again, if you're facing the property from the street to the right before you get to Ms. Silva's property, there is an access road there. It goes back to a unit all the way back by the pond. That's certainly an area over which there are easements. Various people have easements, and I think that is the easement. That is at least one of the easements that I've seen recorded relative to this property. I don't know of another easement that's been recorded, but again, I'm seeing heads shaking in the audience, so I believe I got that one right. That's the easement to which they are referring.
yeah,
Mr. Chairman,
And correct me if I'm wrong, that
Put
easement
that
they
on
were
the map
referring
on the
to,
screen.
that was for the whole HOA community to have access to it? Is that correct, my understanding?
That's the one I was referring to. So if you're looking from the street at the property, on the left-hand side, there's a fairly
Yeah.
wide easement that goes from the layout of this street down to the beach, down to the park. And so that's the piece.
Mr. Hartman, is there a way that you can put that up on the screen so that the board members, and I apologize, I know it is a challenge, but it is obviously much more helpful for us to understand if we can see it. Not everyone has the property fresh in their memory, the way the people who live with it every day do.
It's to the left of actually, would be the right of the property that's on the left.
On this map, it would be on the left.
Okay.
Oh, no, I apologize. No, to the right, that goes along the edge. So along the unimproved area, and then you'll see there's a cart path that says that it is an unimproved path.
Right, Little Pond Road, is that the one you're referring to, or the one?
So can you see the screen, Carl?
Yeah, I see it.
So this is the access easement, the easement for access to the beach or to the park. So it's this piece right here. So that doesn't preclude the property owner themselves from using it, say, although in this case, the driveway was right here, a common drive that would come here. This would not be used for access. And the proposal here is a single common drive. But there's nothing in that easement that says it can't be used. It's owned by property owner. It's this piece that has to remain open, and they couldn't block it, say, build a shed or build a
Right.
fence that would prevent people from enjoying the rights to walk along this access easement. So a driveway, tree clearing, as was pointed out, those things could all occur, but you couldn't do something such as a fence or a shed or something that would block that. And again, I'll go to council to his opinion.
Yep, no, I agree with that.
Okay, and so based upon this photo and the new proposal, the lot that, as I'm looking at this on the right upper part would be the lot that would be removed as the fourth lot, is that my understanding?
Yeah, that's a good question, Mr. Donaldson. So, we haven't produced a three-lot plan yet. I think step A is to see if this board would see fit to allow us to move forward without having that condition hanging over our head. And if so, then we'd have to come back with something that, does create three lots. And again, we've offered to give the planning board a level of oversight once we do come up with that design.
So Carl, I think briefly that what that means is that we have 4 lots now would be reconfigured to 3. We know that there are neighbors with concerns about either the rights to the one house down closer to the pond and that access easement, or the closest abutter. So I think what we'd be looking to do is, if the board was inclined to do the 3-lot alternative, to reconfigure this completely to figure out what makes the most sense to provide the best buffering, screening to the neighbors, allowing for that single common driveway still to be the sole access point for those 3 units, and how do those 3 units make the most sense in some fashion here. And that would be the details that would have to be worked out.
And they're looking to build 3 separate individual units on the lot, is that correct?
Yeah, so at the moment, Mr. Donaldson, we're just trying, like I said, step A is, let's see if 3 lots is feasible, and if so, then we'll come back and try to configure them in a way that passes muster. We're not proposing development at this time, and I don't know when or if that would ever happen, but I guess to be candid, I do believe that would be the eventual intention, would be a single-family residential house on each lot. Again, that's not really what we're presenting tonight, but that's kind of what we discussed so far.
Yeah, well, I do understand that may not be what you're presenting, but I would like, trying to wrap my head around what I would actually potentially be giving you
Right. Yeah,
in my vote
Yep.
and the possible consequences after that.
So, so we're in a residential zoning district, we're in our R25 zone, so, you know, we'd, yeah, we would, you know, that would be the kind of by right, you know, application.
Right, right, and then anything else would have to come to the board for approval as well. Anything other besides the right of,
Yeah,
right, yeah.
I mean, for instance,
Okay.
I don't even think commercial, I don't think this board or the ZBA would even
Well,
have the
yeah,
latitude.
no, definitely not, but I'm saying within reason.
Yeah, right, yes, exactly. If, I mean, for instance, if, at one point, just to be transparent again, I think it was 2006, a VOSD plan was presented, I think it was 6 lots, on a preliminary basis, so something like that would be within the discretion of the board. So let's say we, you know, produced a 3-lot A&R plan, and, you know, this owner or future owner decided not to move forward with developing on that basis, you know, something like that would require, you know, a planning board approval, and that would be discretionary to the planning board.
Okay, thank you. I don't have any more questions at this time. Thank you. Back to you, Mr. Chair. Thank you.
Thank you, Mr. Donaldson.
So if I could, so partly maybe Carl, this will help. When I heard that they were proposing to agree to no more than 3 lots, I thought, well, how, if the board was inclined to support that, would we frame that? So this is just the notes I took. A maximum total number of 3 lots, access via a single common driveway, can be created on lots 3939 and 3940, as shown on the current town assessor's map. The final lot layout, screening, buffering shall be approved by the planning board prior to endorsement of an A&R plan, approval not required plan, and also make it subject to the fire department's final review and approval of that common driveway for access. So that would be, I don't know if that helps answer your question, but that would be the kind of motion I would suggest if the board was inclined to support the 3-unit option.
And thank you for the clarification. I did one on the, far as the fire department access. That slipped my mind. I did want to ask about that, and also just, and have that recommendation as well. So, thank you for, reminding me of that, Lee. Yeah, I have no further questions. Thank you.
Thank you, Mr. Donaldson. Mr. Mand.
Thank you, Mr. Chairman. I think I agree with Carl in that I'm trying to get my head around this. I've heard so many things tonight that I was not aware of in terms of the residents' belief that there is, in the record, many things which seem to support their assertions about the concrete nature of the original condition and how it's in the record. It may not be in the record where you would usually find it, but it's in the record in many other ways. It's indicated in many other ways. And while I really applaud the applicant for their willing to, at this point, compromise, I'm not sure if I can move forward approving that without more clarity about the issues that were brought up by the residents tonight. I heard many things about various documents, various things in the record, things that I thought I had done my due diligence on this to a degree, but I underestimated the complexity of it and feel that that I can't go forward without a greater understanding of that. I could be convinced, but at this point I really think I need to review a lot of those things, see them apply to this specifically. Again, I commend the applicant for their willingness to compromise, as they stated, down to 3 lots with the ability of the planning board to do some, have a say in some buffering and site plan, all of which I would hope for, regardless, considering the sensitive nature of this area, its proximity to Morton Park and the ponds. But again, there seems to be so many things that were brought up tonight that I had not been aware of that weren't necessarily in the record that I could have reviewed. I'm not sure. Perhaps if I'd asked more insightful questions of staff, I would have understood this more clearly, but they brought up many things. I don't know if I could even go through them. All the various things that seem to affect the deed. So I just will state that at this point I feel unable to approve this because I don't have clarity as to the legality of this. But I wish that there was a buy-in from the residents for this kind of compromise. It seems to me that that should be attainable. It seems to me that without knowing the full ramifications of this, that the applicants seem to be doing a lot of what we would have asked them to do. So I'm hoping that perhaps this continuing and some greater meeting of the minds take place, but at this point I don't feel comfortable in supporting this without further review on my part of all the things that were brought up tonight. Thank you.
Thank you. Mr. Hartman, I know that you referred this matter to council to get a qualified opinion, at least.
Yeah, we don't have anything in writing, but the indication was it's a mess, for lack of a better word, because you do have conflicting things. You have an A&R plan that the board determined you had adequate frontage on a way. You have a vote, but the vote was never perfectly perfected. So again, I think she indicated that, there was, the record's not clear, and that there's nothing definitive that would point one way or the other. And again, that's why, from a staff standpoint, I think the compromise makes the most sense.
Thank you. Mr. Grandy.
Thank you, through the chair. Thank everyone for coming this evening. I would agree with what your staff just said from legal. It's a mess. You have a plan that was approved back in 1984. Then you have a four-lot a subdivision, 4 lots approved by the planning board in 2012. But to my understanding, what I heard earlier is the planning board wasn't aware of the language that was in place previously. So if we go back to the original approvals, I would ask the question, in some of the requirements, it says unless it is improved. So was the intent of the improvement to be an actual cul-de-sac? So by extending a shared driveway off of that particular layout that I'm looking up on the screen, how does that create, to me, a safe situation or an improvement that was asked for back when the original plans were approved? So and I agree with what Mr. Mann has said also, there happens to be a lot of gray area here. We have reports from town engineers at different time frames and different dates, which I'm not privy to, obviously, because I don't have them in front of me. We talk about snow removal, safety, the fire department be able to bring their vehicles in there. There's a lot of questions when it comes down to approving this or not approving this. Because obviously the developer is not going to create a 3-lot subdivision plan and spend the funding to do it unless he has some type of direction from the planning board if it was going to be approved and accepted. So I will ask the proponent this evening, in all this time and continuances that we've had, how many meetings have you had with the residents to discuss different options?
Yeah, so the residents have had 2, to our knowledge, spokespeople, for lack of a better word, and they've sort of engaged with us on behalf of what they claim to be, I think, a majority of the residents is kind of the language that I've heard. It's unclear to us how many people they're actually speaking on behalf of, so, but that's who's reached out to us, Mr. Grandy, and again, I had kind of jotted some notes down on the topic here. Bear with me, please. Yeah, no, I know it was Kevin. The neighbors, at one point, they were going to have a neighborhood barbecue. I think it got rained out on September 7th. But then Kevin reached back out and spoke at length with me and with Mr. Sawyer. And again, Mike had actually offered them a written proposal to post $50,000 into escrow, to allow them to, attempt to form an HOA, engage legal counsel, draft documents, take that step, use whatever portion of that fund they wanted to resurface the cul-de-sac area, to explore a pathway to town acceptance of the roadway with that fund. So, again, among the dialogue, there was a concrete proposal made. There's been 4 or 5 conversations between me, Mike, Kevin. I've spoken to Kevin once. I think Mike sat down with him in person and spoken to him on the phone at least twice. So there's been some dialogue. And just while I have the floor here, your point about roadway improvement, just to kind of address that, the way I read that condition, Mr. Grandy, and again, it's the language in the vote, I'll call it, it calls for a covenant with the developer that no lots fronting this portion of the layout with construction waivers will be further subdivided. This portion is referring to that dogleg out toward Morton Park. So again, I think the intention was, hey, look, don't subdivide that lot at the end unless you're prepared to improve that roadway going out to Morton Park, which, Mr. Sawyer didn't want to do, and I don't think, frankly, the town wanted to see it because they didn't want people using that to get to Morton Park. But my position is, if he were to improve that roadway, the covenant becomes moot. So again, I think that's what that improvement language speaks to, in my view.
Okay, so obviously neither one of us were around when it was originally discussed at the planning board meeting. So we really don't know the actual intent
Right, but it talks about a
from that
50-foot.
time frame,
It
right?
says 50-foot road layout, that's the 50.
I know that's how you read it, and I appreciate how you read it. Okay, so there can be read in different ways, obviously. Let's talk about the 4-lot subdivision plan. Do we have that available? That's the one that was approved back in 2012. That's it.
And we do have the endorsed Mylar.
So all that does is run a driveway off of that end of the road, basically, a shared driveway. Okay. Thank you, Chairman. I may have some more questions, but I'll turn it over to you, sir. Thank you.
First, just a couple of quick comments, because people are talking about a lot of legal issues. The residents have made a very great presentation. It was very helpful. But I note from the presentation, a lot of it was questions. Does this apply? Does that apply? Can this be done? And the answer is, this body can't answer those questions. We're not a legal board. We're not judge and jury. You've literally asked a great number of questions, all very cogent questions, which can't be answered because we don't have clear documentation. Some of the documentation, in fact, that the residents have cited to actually says some contradictory things. For instance, the letter, which again is just a letter, it's a letter from a planning assistant to the town clerk, talks about some ideas and some intent. One of the things it says in that letter is that all of the votes, including the covenant, were conditional upon completion of all work on the ground within 2 years from the date of endorsement. Meaning that if things weren't done within 2 years, the entire vote disappears. Meaning that in essence, the 1978 vote is gone. That's an argument that can be made. You have Mr. D'Ambroso's argument, which is that if the road were to be extended and cleared, that under those circumstances, further subdivision could be allowed. That's an argument. We have questions, again, regarding the... Excuse me, sir. We can hear you back here, which means that you shouldn't be speaking. Thank you. We have questions regarding the cul-de-sac. The word temporary. No one can answer that question. There is no one in this town available at this point who can say why the word temporary was put there, what temporary means, and what the impact of the fact that a temporary cul-de-sac has been sitting there for 47 years now. These are all legal questions that cannot be answered by this board. I don't know what the answers are. I have my opinions, but they are just that, opinions. And if taken to court, a judge could decide that they agree with me or completely disagree with me. And that's a long and arduous process, one that more than likely, from my 34 years of legal experience, is no one will be happy. People will spend a lot of money, and results will happen. The owner of the property will probably have things happen that they're not pleased with. The residents will more than likely have things happen that they're not pleased with. That's how these things work. And I don't think we want to get to that point. That was the problem we're trying to deal with. This is why planning is not to be left to the timid. So we look at some of these things. So again, my questions really relate to what can be done with this property otherwise. So again, let's just say hypothetically, Mr. D'Ambroso's argument is correct, and the property, if the road is extended, what could then be done? Could that then create a 4-lot? Could it create a 6-lot? Could it create an 8-lot subdivision in there? I don't know the answer to that. Mr. D'Ambroso, have you done any research on what Mr. Hartman has given us some general numbers as to what could go there.
I'm trying not to poke the tiger's nest too much here.
I understand that you don't want to, I'm asking you the question because, again, we're looking at best case and worst case scenarios here. And, Mr. Donaldson raised the question, what does our vote mean tonight?
Yeah.
What our vote means is it allows certain things, and it also means that it takes certain things off the table.
Yeah.
So that's the perspective. So I want everyone to understand what it is the parameters that we're looking at.
I mean, given the lot area and the amount of frontage, I think there's the possibility to do many more lots than 4.
Okay, I can accept that as an answer. Thank you. How wide, so that extension would be a standard road, 50 feet? Is that, Mr. Hartman, if they did the extension, how wide would that road extension
So
be?
you're talking hypothetically if somebody came in?
If somebody came in and wanted to
So
turn
you-
that into
what you
standard
would-
road?
What you would do essentially,
It's a 50-foot layout.
so essentially what would happen is that you would look at an extension of a road here with a cul-de-sac that would come in here. And then you would have lots facing off of that cul-de-sac. So again, maybe the temporary cul-de-sac disappears and then a cul-de-sac is built here to provide frontage for how many lots that they could then get off of that.
And what about just the road as was designated in the 1978 vote?
So the 4 would be so if they came in and improved this road, the 4 would be the absolute maximum. If they went in and took this piece right here and improved it to subdivision standards, which would be typically 1 sidewalk, 24 feet of pavement.
Okay, and that's right now, that was the small cart path that we walked down that's otherwise tree-lined.
Correct.
Okay, so I'm going to go out on a limb here and say the residents don't want that to happen. So we want to avoid that. I have no further questions at this point. I think maybe if we end up with a motion, I can do some further comment on that at that point, but I think the questions have been answered. Anything else from members of the board? Any further questions for the applicant or for staff? Seeing none. So we're at the time where we need to either say we're going to make a decision or not make a decision. So at this point, Mr. Hartman has put forth a proposed motion. So I'm going to ask, does anyone wish to make that proposed motion?
May I interject before you guys take that motion up?
Sure,
Just
Mr.
because this
D'Ambroso.
is sort of kind of our offer. It's the board's prerogative, but it is our offer. I would suggest that, I appreciate the motion or the proposed language. I'd suggest that if the planning board has kind of site plan authority going forward, we don't need that vote to be too narrow. Specifically, my client's not willing at this point, especially not knowing how the board might want the lot lines drawn or the grades changed or the screening done, to commit to a single common drive. That may well be how it ends up, and again, you're going to get a look at it and some say on it, but that is unduly restrictive, and we wouldn't want to move forward if that were the basis of the planning board's vote tonight.
Okay, Mr. Hartman, why don't you read out the proposed motion then, absent that common drive?
So it would be a maximum total number of 3 lots, access via a single common driveway, can be created on lots 39, 39, and 3940 as shown on the town's current assessors map. The final lot layout, screening, buffers shall be approved by the planning board prior to the endorsement of an approval not required plan, also subject to the fire department's review and approval of the common drive.
Well, you'd have common drive, so I would say fire department's review and approval of access plans, as well as obviously the standard engineering requirements.
And there was another common drive reference earlier. I think he read his original language, right?
Because obviously the residents had also raised the question as to whether or not a single drive would be accessible and adequate, in which case there may be need for a second. And so I can understand that. So that would be the motion. Do I have a member of the board who wishes to make that motion? Hearing none. The question then, Mr. D'Ambrosio, is do you wish to have a vote taken on the submission on the 4-unit, on the 4-lot, or do you wish to withdraw that without prejudice at this time?
Well, I guess I'd like to have a minute to talk to my client. My gut is if you guys can't even muster a motion, and I don't mean that in a disparaging way, for 3 lots, you're probably not going to go for 4, is my gut check here. I was hopeful that that 3-lot was it's a significant concession, particularly with planning board oversight, to make sure that it's done in a tasteful and safe and nice way for the neighborhood. So I'm a little disappointed that that's not something that the board wants to embrace. But can I have a minute to talk to my client?
Absolutely.
Thanks. Step outside, Mike.
Why don't we take a 5-minute recess?
But if we were to submit a proposal along the lines of kind of what we just discussed here, and maybe it's a question for staff, maybe I should know the answer, but would this board be compelled to vote it one way or the other, ultimately? Because that's, if you're not willing to move it, which that's your prerogative, then maybe that's how we get you to consider it in a voting fashion. I just thought I'd ask the question while I have,
I believe that the alternatives would be you can either continue this and submit that as an amendment, or withdraw it and submit that as a separate plan. Either way, if there is a plan before us, we will have to take a vote on it. That's your right as an applicant, or your client's right as an applicant. They submit something to us, we will have to vote on it. Right now, we only have the one thing that is
Right.
technically submitted to us.
right, but we wouldn't be submitting a plan, we'd be submitting a request to amend the condition,
Request
right?
to amend the condition
Yeah,
to those.
yeah, so you would take it up if we,
We would take it up, and obviously, under those circumstances, the residents may have more opportunity at that point.
Yeah.
Planning board members who have said that they are concerned that they don't have adequate information might have more time to review as well.
yeah, okay, so, Lee, you agree that we can amend? Is that the appropriate path as far as you're concerned?
Under this current one?
Yep.
Yes, yes.
Yeah, and not
I
have to
think-
withdraw and
yeah.
file, I mean, there's no filing fee, there's no, I don't know
No,
that.
and I think what you would need to do is just give us a verbal commitment to a continuation of the action timeline.
Yeah,
And then
so-
we can continue it, and we would have to continue it to a time and date certain.
Right, and we give you plenty of time, to let, Mr. Mann and anyone else kind of bone up, and maybe even the neighbors, we could have some more dialogue with the neighbors if it's helpful, so,
I would just remind you that, of course, under those circumstances, even though we have technically closed public comment,
Yep.
we would reopen public comment on a new submission
Sure.
that wouldn't.
sure, no, we wouldn't fight you on that, that's fair, so. please.
Yes.
Yep, yeah, I guess we'd continue out. Mike, are you here for the next month or so? I know you're going.
So the next two available dates would be December 19th November 19th or December 3rd. And again, the board has to go to continue to a time and date certain.
I thought we were not meeting. November 19th. Sorry, I thought that we were meeting, it's the 2nd and the 4th of November, Wednesday. I thought we
So-
were meeting on the 12th.
The 12th is a joint meeting tentatively with the select board, so that would
It
not-
is, but it's still also our regular meeting. So the select board has indicated to me that if we are meeting, it's a one subject, and then they would leave. It
Okay.
would be our meeting. So we would go forward on the 12th, and we were not going to go forward on the 26th, obviously, because of Thanksgiving. And I thought the plan then was to meet twice in December, the 3rd and the 17th then.
Okay.
So I would say then it would be tentatively the 12th of November or the 3rd of
So-
December.
And so at this point, just for the 12th, we had talked about, well, on the 19th, but we can certainly look at a Pine Hills update on where they are with their final build-out. And then we have an informal request for the Bump Rock Road property. Another property owner wants to come in and do further subdivision off of Bump Rock Road. So those are two other ones we had tentatively put on the 19th. Maybe we can push the Pine Hills to December.
We could
and
certainly do that.
Okay.
We'd be looking at that later date, December 3rd is what works for
Okay.
my client, if
And
that,
then that solves it.
Okay. So at this point, I have a request to continue this matter to December 3rd, at which time we will probably be looking at a revised proposal.
And for the record, your client is good with the extension of the time? action
yep,
time?
yeah, we agree to waive any statutory time period.
Thank you.
Yep.
Okay. Thank you very much.
Do you need to vote?
I don't think
No?
we need to, all right. So
Make a motion to December
So, and
3rd.
it would be to continue, to reopen and continue the public hearing to December
3rd.
3rd, 7 o'clock,
I have a
Seven
motion.
o'clock.
7:05.
I have,
7:06, how's that?
I have a motion. Do I have a second?
Second.
I have a motion and a second. Discussion? Seeing none, I'll call the roll. Mr. Donaldson?
Yes.
Mr. Mann?
Yes.
Mr. Grandy?
Yes.
Myself, yes.
All right, thank you, Board, and
Thank you very much.
Thank you, Sleepy Hollow Drive folks. Thank you.
Let's get Mr. Bennett back in. If he hasn't fallen asleep out there. Yeah, let's bring the copies for everyone. I'll make sure that everyone gets those. Thank you. Next on our agenda this evening, we have ZBA 4189, 2 Commerce Way, High Rock Cranberry Crescent, modification of special permit case 3764, required per section 203-3D1, Table 1, to allow additional architectural signs and freestanding signs for an automotive filling station. This is a ZBA matter, so we are advisory to that body. Good evening.
Good evening, Mr. Chairman. My name is Peter March, New Hampshire Signs, 66 Gold Ledge Avenue, Auburn, New Hampshire. So we're applying for approval for signage at a new build gas station, 2 Commerce Way, Plymouth. It's kitty corner to the Market Basket. And we're here to ask for your blessing and or comments on our signage request. So the project has been underway for some time. And the project is being developed by Energy North, a established petroleum distributor from Lawrence, Massachusetts. It's known for quality and sympathetic designs of petroleum gas stations. It's been underway for some time, as I said, and a portion of the sign package has either been permitted already and is within code and has not been permitted. So in summary, I don't know if I put a table into the submission. Would you be able to find that table? If not, I have a copy here. The narrative, thank you. That's that one. Oh, down a bit more. That one. You're younger than me. You should be able to do it way better.
So while they're doing that, I just have to point out a $2.25 a gallon. I think we need to move this project along.
So this is the
Yeah,
table.
if we're approving any signage, it's for those specific numbers.
Thank you. So there are really four components to this project. The MID, or the street sign, and we are allowed one. We're asking for a second one. A canopy signage on the mobile canopy. Should have pointed out this is a mobile site. We're allowed 40 square feet. We have 11 and a quarter. So we're within size. We've been given permits on the building signage and the signage for the car wash. You can see the permit numbers there. And then the last component is Synergy, the mobile Synergy elements that attach to the columns and attach to the dispensers on the station. Specifically, we're requesting a second road sign. That's the item that is probably going to occupy a little more of our time. We're requesting a second road sign where we're only allowed one, but we are allowed in excess of the limit established by Table 1 or require a special permit from the ZBA. As I said, the permitted signs, retail Hafner's Deli, car wash, and the Hafner's 8 kick sign have all been approved. They're all halo-lit channel letters and conform to the code. The synergy elements are these elements here. And these elements were approved on the sister site to this, which is 130 Commerce Road or Commerce Way. Synergy elements are a mobile forecourt strategy to try and direct traffic onto a site in an efficient and safe manner. They are suggestive, they're not obligatory, but they consist of red elements that essentially move traffic or suggest that traffic enters a gas station in a particular way. Gas stations are by their nature fairly dangerous places for individuals getting out of the car, going in to buy a cup of coffee, and interacting with vehicles that are arriving to fuel. So the ZBA approved this subset on the 130 Commerce Way. We're really asking for exactly the same on this side. So they consist of a blade, a koala, which hangs on the pole and is used for either safety information or promotional information, and then a pump wage, which is just a typical pump number. So there's nothing particularly contentious about that. And as I say, it was approved by the ZBA on 130 Commerce Way. As far as the canopy signs are concerned, we're allowed 40 square feet total. We're asking for 2 11.25 square foot mobile signs. They will be halo lit per code, and they're small, and we're really only asking for 2. And the orientation is on the canopy here. As far as the ID sign is concerned, now I will need help getting back to that one. Otherwise, you've got the canopy signs as well. So I see we have all the renderings there, we just didn't use them. That's where we'd like to be right now. So this is an externally illuminated sign. It conforms to all parts of the code. It has automated scrollers in it for the price. Scrollers are not the LED prices that the town does not allow. Scrollers are more akin to the old bus number on the front of a bus, and it's a rolling scroll of numbers. It's externally illuminated. It just automates the process of changing prices on the sign. And again, it contains a couple of tenant panels, a car wash, and a C-store or fast food type tenant panel. We're looking to put 2 of those signs up, not just the one. The reason for that is that this site has 2 distinct entrances, one on Commerce Way and one on Carver Road, and they're not really related to one another as far as a passing motorist would be concerned. So what we're hoping to do is we'd like to put one on the Carver Way entrance and one on the Commerce Way entrance. So the ZBA is allowed to do that if we approve the requirements of the special permit. So that's essentially what we're looking for there. And again, this sign is externally illuminated. 70 square feet. I feel that our request is consistent with the other signs in the area. It's consistent with the use of a gas station. One of the elements of a gas station is that price and brand are very key to advertising. It's one of the few businesses that changes prices on a daily basis. Therefore, price is extremely important to the success of a gas station. If we're talking about the special permit, I think that this use is consistent with the purpose and intent of the district, which include the core goals of economic development, infrastructure maintenance, improvement, and safety. Adequate facilities will be provided for the safe and harmonious exercise of the special permit. There's adequate power, adequate space for the proposal. There will be no hazard to pedestrians or vehicles, In fact, these signs will promote clear signage, which in of itself allows for traffic safety. There's no nuisance or adverse effect on the neighborhood. It has a positive effect on the neighborhood by adding needed infrastructure. While we were actually parked looking at the site, a car pulled up and commended us for putting a gas station there, saying that the one was definitely needed. And again, the sign package we're requesting relates to the architectural features of the site as a whole, as in proportion to them, and I'd argue they're clear and appropriate. And now that I've discovered any of the other drawings, I can actually pull those up as well, or with help I can pull those up.
Anything further that you need to?
Nope.
Bring it to staff?
Thank you. So this is a modification of the existing master signage plan for this commercial development. Staff is recommending a favorable vote for you to recommend to the Zoning Board of Appeals the issuance of this permit with the waiver sought. It seems like a reasonable request given the nature of the site, the proximity to other active commercial uses in the area, and the intent of the signage to provide an improvement to circular function of the area, circulation, I should say, of driver safety and information. And as I mentioned, given that it's frontage on 2 different roadways, we find this to be a reasonable request. Thank you.
Okay, thank you. I'll open it up for public comment if there's anyone who wants to talk about this matter. Anyone in the room wishing to be heard? Seeing no one. Anyone on Zoom wishing to be heard?
If on Zoom you want to be heard, raise your virtual hand. I am not seeing anyone looking to be recognized.
Okay, I will bring it to the board for questions for the petitioner. Mr. Bennett.
Thank you, Mr. Chairman. I only have one question. It's really more to satisfy curiosity here, but there is a lighting plan which is part of the design set for the site. I just checked the zoning regulations. Lee, I thought there was a limitation of like 1 lumen at the property line or something like that. I don't see a specific number like that in this code.
We can confirm with the building department, so they make them go through an analysis to make sure they're in compliance with the light pollution bylaw of the town. So if you would like, as part of your vote, we can just confirm to make sure that that's being double-checked with the building commissioner.
Okay, thank you. I think that my question came about because it doesn't look like in their lighting, I'm not sure what you call it, it's the lighting plan that shows the lumens throughout the site. I don't think that these signs are accounted for in that. I don't think it's a big issue, but it probably should be checked. That's the only question I had. Thank you.
Thank you, Mr. Bennett. Mr. Mann.
Thank you, Mr. Chairman. Let me be clear, Mr. Hardman, the waiver or the special permit to allow an additional architectural signs, that normally they would be allowed one of these tall, and I know the terminology, escapes me, one of these tall signs that
Freestanding sign?
Pylon. What is they need a special permit to have a second one?
That's correct.
Okay, thank you. Because though I understand the rationale in terms of signage and visibility in association with the site, I also understand the West Plymouth Steering Committee and in general West Plymouth is making an effort to segment or separate commercial zones, which they have plenty of, from their more rural or suburban or treed zones. And West Carver Road heading into there, heading toward the, I believe, let's see, does that head toward the elementary school on that side?
That would be Plimpton Road.
Okay, that's Route 80. But on that side, I think that their inclination would be not to have a second sign, and it is, a tall commercial sign, and they're normally allowed to have one. So I'm not sure beyond, the traditional reasons they would put as much signage as they want, that would be preferred to have that sign in that location. I can understand within the commercial development, within the market basket development signage along there, and that is the main way that people come to that particular spot and come up through there, the signage being necessary and in keeping. But as you start to encroach upon the areas outside of this development, I think there's an inclination to try to reduce that spread, both of light and lumens, but also of commercial signage and indications of that. And I don't know why we couldn't have a smaller sign at that location, not to have the pylon. That's just my general understanding of what they would like to see in that area.
Anything else, Mr. Mann?
No.
Thank you. Mr. Donaldson?
I know you mentioned it was previously permitted in another location. My feelings in regards to signage of this type and degree, and even though it may have been a one-off, what is, other than marketing, would be a reason why we would let you, or we would vote to allow you to have this type of condition for the second time? What benefit is that going to give the location and the neighbors in that neighborhood? If you could answer that question.
Yeah, I think the reason for the second sign is because there are two entrances to the property, and the two entrances are very distinct, and one will serve traffic on Commerce Way, the other on Carver, and there's no easy way to serve both traffic using a single sign. So that would be my answer to that. And yes, it is most of the purpose of signs is commercial. It's to draw attention to a service or some aspect of a commercial operation. In this case, as I stated, one of the things that is key to petroleum is firstly the brand. The reason the brand is important is because many people use loyalty cards, and many people seek out a particular brand. So the actual brand component of the sign is important. The other thing that's important is the price. Price is a key driver to getting motorists onto a site, and consequently, the more motorists use the site, the more successful the site is, and the more likely it is to be a commercial success.
So is this lot on a corner of the property?
Yes, sir. It's right on the corner of Carver and Commerce, I beg your pardon.
Okay.
It's essentially, if you looked at the Market Basket, if you were standing at the front of Market Basket, it's to the right of Market Basket, and it's almost exactly a mirror image of Market Basket, because Market Basket is also on a corner. So that creates unique challenges as far as actually displaying things like brand and price are concerned.
Lee, I just want to make sure I'm correct. Didn't we approve, is in that same area, a car wash and gas station on the corner across from the Market Basket?
This is that project, Carl.
This is that project.
It's the same project, okay. All right, I just want to make sure, okay. All right, I have no further questions, thank you.
Thank you. Mr. Grandy?
Okay, I do have something related to what Kyle was suggesting as far, and Frank mentioned just one sign. You could put one on the corner behind that radius. Is that a retaining wall I'm looking at? on an angle, so you get the traffic from both ways. I have seen that done on different projects also, just a suggestion. But anything to do with signage as far as helping business is concerned, I am for. So we want to support our businesses so we can bring in more taxes, bring people in, and move forward, and being friendly with business. So, thank you, Mr. Chairman.
Thank you, Mr. Grandy. I appreciate the need for the branding. I appreciate the need for the prices. Obviously, those are two very important pieces of information for the consumer. I understand the idea of having signage at two locations in this particular instance. I think that actually is a benefit to the residents in the sense that I think it improves traffic. If people can see the sign and they're noting the entranceway based upon where the sign is.
Yes, sir.
So I do understand that. My concern continues to be that this is a hodgepodge. It's sign over sign over sign. I'm looking at mobile. I'm looking at Hafner's. I'm looking at multiple prices. I'm looking at Hafner's Car Wash. I'm looking at Jack's. All up and down. You would have thought that this was the sign for the entire shopping center based upon that. That's too busy from my perspective. You have the Hafner's Car Wash sign on the car wash, along with the Bucking Bronco. You have the Hafner's, you have the Jack's Kitchen on the building itself. You have two mobile canopy signs. There's a lot of signage on this, a lot being proposed, so adding yet more signage. Again, I'm fine with signage that helps delineate an entrance and provides that critical information. But that extra advertising, above and beyond, if it were nowhere else on the site, I could say, all right, I understand why it's there. That's my concern. I would like to see those signs shrunk down. That would be, again, so that would be my recommendation, which is to say, yes, for certain advertising, critical information, and directional purposes, no, because it's too repetitive for some of the other aspects. So that's my 2 cents. I understand your chart was very good and very helpful explaining what it is you're asking for, what's allowed, what you're asking for on top, and that was, so my questions were answered by that. So that's just my thought process. Anything else from members of the board?
Mr. Chairman, I would just suggest that, as we recommend to the ZBA, that there's a possibility of having a smaller sign at that Carver Road entrance that has the mobile brand and price. And I've seen that in other filling stations in the area. They don't have to be the massive conglomeration of signage that this one indicates a second time. Thank you.
Well, Mr. Mann, would you like to make a motion to that effect?
Yes, make a motion to that effect.
Okay, I'm going to interpret it as being a motion to recommend to the ZBA that we approve, that we would recommend approval of the requested signs on a reduced size basis to limit the information to the branding and pricing for those pylon signs. Does that sound about right, Mr. Mann?
Yes.
That's the motion I have. Do I have a second?
I'll second that.
I have a second. Any further discussion? Mr. Bennett?
Yeah, Mr.
First, Mr. Donaldson, yes.
Yes. I'm really in agreement in regards to if they want to have that larger sign, why couldn't it be on the corner that it serves purposes for both roads? And again, I mean, I'm not of the belief just because we did it once, it might have suited the purpose in that other, usage of the other gas station. That doesn't necessarily mean that it's the right proposal for this one to have two signs.
Okay. The only challenge, Mr. Donaldson, is that we don't have the ability as an advisory body to tell them where to put a sign. They have a petition in front of us for a sign. We can approve it, we can deny it, or we can make a recommendation regarding what their application is. We can't really redesign it for them. But
We can make a recommendation for that.
But we can certainly suggest that if they are inclined to go with a large sign, that it be a single large sign at one location. Would that be, so are you suggesting that the motion be amended to
Yes.
recommend the two smaller signs or one larger sign in a centralized location?
Yes, Mr. Chair, thank you.
Okay, Mr. Mann, would you agree with that as a motion?
Can we hear from Mr. Bennett first?
We can hear from Mr. Bennett first.
Thank you, Mr. Manager, Mr. Chairman. So I'm not sure I agree with reducing it to one sign on the corner. I think that the Market Basket sign right across the street from that already sort of clutters up that corner. I much prefer actually to have the signage at the entrances. I think that's a safer alternative as far as directing residents or potential customers into the property. I think that I would like to recommend a modification to the motion that the pylon sign has mobile, then it has Hafner's, then it has the price of the gas, then it has Hafner's Car Wash, and then it has Jack's Kitchen. I would be a lot more comfortable if it was basically eliminated the additional advertising on the bottom half of the sign. In other words, the two lower sections being Hafner's Car Wash, which is got a giant sign on the side of it facing the road already, and at the very least, maybe eliminate it from the side where there's already one there on the side of the building. And then the Jack's Kitchen, I'd be willing to consider I guess what I'm getting at is that you have two advertisements for Hafner's Car Wash on the top, I don't know if that's the north side of the plan there, and then on the Commerce Way side. Then on the Carver Road side, you have the signs on the building and the mobile sign. So Jack's Kitchen is advertised there and twice as well. So I would see if Mr. Mann would entertain modifying the motion to eliminate one or both of the lower advertisements on the pylon sign. That's all.
Well, why don't we continue this then as discussion before we get, I think let's get to a single motion rather than amending it 6 times. I don't need to give Mr. Mann any more gray hairs. So
Concerned about conflict.
I think that the consensus seems to be that, I mean, I would agree with Mr. Bennett. I am in favor, I would prefer the 2 signs because I believe that they delineate the entranceways better versus a singular sign, which someone may be staring at that and not know which way they're going in. So my personal preference, again, is I was fine with the locations because I thought they were safety related. But I'm in agreement that there's too many signs on that. Basically, maybe we say that you allow the mobile, one other advertising and price. And they can delineate, they can put Hafner's on one of the signs and Jack's Kitchen on the other, or the car wash, whatever piece they wish to advertise given the location. Maybe they put the car wash closer to the car wash, maybe they put Jack's Kitchen over on the road because it's more likely to bring people in. That's up to them, but essentially 2 items plus price per sign. That, I think, was Mr. Bennett's suggestion. So from a discussion standpoint, I think that's the proposal, that's the idea that's being floated. I think we're all in agreement we'd like to see the sign reduced in size. So the question is to what? And I think that I think it's a compromise to say that we allow mobile plus 1 advertising plus price. Anyone else feel differently with respect to that?
If I may,
Please.
2 pylon signs. I worked for a company for over 40 years, and the only time we ever had 2 pylon signs is when we had quite a distance between entrances. You've got mobile signs on the building, And at the entryways, when we're talking about no one to be able to enter or not, you could put a mobile enter, smaller mobile enter sign at those entrances, and with an exit sign on the other side. You've seen them done. If you're a sign company, I'm sure you're aware. I'm just, to me, 2 pylon signs, even if reduced, is a little too much in my eyes as far as pylon signs are concerned. So if you did enter exit as far as smaller sign with arrows, and then at the other entrance, the same thing, and the 1 pylon sign, I can't design it for you. You're submitting what you want to submit, so I can only speak as to how I feel
So
as far as pylon signs.
so your thought would be then no pricing?
So if I could too, and the point was just made, so we can give them suggestions, but we have to be content neutral. So
Yeah.
you can give them suggestions, but if they chose, instead of a price to say mobile, instead of a price to say pizza, it's really the size of the signs, size of the pylon, and suggestions of what kind of wording would be acceptable, but it needs to be content neutral.
And are these all internally illuminated? No. Say again?
That's prohibited in the bylaw.
That's right. So I looked at LED lighting inside some of these signs and the details, so am I
They're,
correct with that?
They're halo LED, so they're...
Halo light with LED lighting.
Correct,
Yeah, but
halo
right?
LED with LED.
So we don't need to light up the world with your plaza here,
No,
so
so
to
they're
speak.
right against the wall, so essentially the outline of the sign
And
is...
the
what
halo
you
is
see.
in keeping
So-
with our laws?
Yes, yes. So what a halo light is that you have an oblique, opaque letter. You can't see through it. It's lit in the back, so you have a backlight, but the letter itself is solid.
Yeah.
So if I could just make a suggestion, as I hear multiple sets of options here, you might be best, because this is advisory and it is going to the board, to just simply say, because of the size and scale, you can't support the proposal, and recommend that something significantly less be considered. I think to try to come to a conclusion as I'm listening tonight and try to design this on the fly might be a little more than
Yeah.
we can do in a night. And so it might be as simple as to say, because of the size and scale, recommend that it not be supported without significant reductions. That would be my humble suggestion.
Thank you, Mr. Hartman. But we don't have seconded motion, so we can always put a new motion out there.
I withdraw my motion in favor of Mr. Hartman's motion.
Okay, so we
It
have...
wouldn't be my motion, it would be my suggestion.
Mr. Hartman suggested motion that he insisted we abide by.
Okay, so we have a motion to recommend non-approval due to size and recommend a reduced scale.
And that refers just to the ID sign, or does it refer to all the other signage as well?
Well, so that's just to the ID signs. So let's go through that. So the other signs that you're seeking were the, let's see, is it the retail Hafners?
No, those have been approved.
Those have
Mr.
been
Chairman.
approved,
Yeah,
so-
so you,
Oh,
all the building signs have all been approved. We have permits in hand. for
Okay,
those.
so
It's the pylon signs, right?
what's the pylon signs? What other signs are,
So the pylon sign one would be approved under current code. We're asking for a second.
right?
So I think what we're prepared to do is reduce the size of both of those to get somewhere to what the board wants. And I think we're also going to take the board's recommendation to say the one that says car wash is closer to the car wash, and the one that says, whatever the other services at the other entrance, and reduce those signs. So we'd be happy to do that. The canopy signs, the mobile canopy signs are the other elements. They're these ones here. We're allowed 40 square feet. We've got 11 and a quarter. So we're well under what we would be normally allowed on that. And then the last element is the synergy elements, which are these ones, which the ZBA approved on 130 Commerce a couple of years ago. So those don't seem to be particularly contentious.
No, so the synergy ones are safety-oriented.
Correct.
And I think, well, why don't we go through them very quickly individually so everybody can see. So does anyone have any comments or does anyone object to the synergy signs? So the motion would be then, so whatever motion we would have would include recommend approval of the synergy signs, the canopy signs. Those are, again, that's a recommended, that's much smaller than otherwise would be allowed. So they're asking for 2
Yes, sir.
smaller ones rather than 1 large one. Oh, nope, the canopy signs as well. Both, gentlemen. This is canopy. Canopy first, then we'll go to pylon. So these are 2 canopy signs that are also being requested. Just they say mobile. Does anyone have an objection to that, or should we include a recommendation to approve that in the motion? Okay, so we'd recommend approval of those signs in the motion. Now the pylon signs. We would recommend approval if significantly smaller, reduced to a size that would reflect the mobile, 1 advertising, and price. That doesn't necessarily mean that that's what we're requiring, but merely that's the size that we would be recommending. And our recommendation, to the extent that the petitioner would like to take it, is that they include the mobile, the price, and 1 advertising reference.
If I could, it might be good, since that seems to be a cooperative effort, to note the willingness of the applicant to comply with the board, something to that effect.
And I think that, and that's our recommendation, per the reference of the applicant's willingness to do that, with which we greatly appreciate.
The board is pleased to
The
note.
board is pleased that the applicant was so cooperative in listening to our suggestion. And we support the applicant's desire to work with us. So, is someone willing to make that motion?
So moved.
Do I have a second?
Second.
I have a second. Further discussion? Hearing none, call the roll. Mr. Donaldson?
Yes.
Mr. Mand?
Yes.
Mr. Grandy?
Yes.
Mr. Bennett?
Yes.
Myself, yes.
Thank you very much.
Thank you. Good luck with the
Have a
ZBA.
good evening.
Thank you for your help.
Next on our agenda tonight, we have another ZBA matter, 4190-233-235 Sandwich Street, Brian Ellis. This is a special permit required per section 203-9C and 205-4 to change a non-conforming use to another non-conforming use in the R25 zone, and per section 203-7J to waive required off-street parking spaces to convert a retail drugstore to a deli.
How you doing?
Good evening.
Good evening. How are you? This is my first time doing this, so bear with me.
You're already doing a great job.
Thank you. My name is Brian Ellis. I'm here tonight regarding 235 Sandwich Street, a small, long vacant storefront that used to be Ed's Discount Drugstore. I'm applying for a special permit to change one non-conforming use to another and to waive the off-street parking requirements to allow me to open a small neighborhood deli in the space. The property has always operated as a commercial storefront, but since it's located in a residentially zoned district, it's considered a non-conforming commercial use. My intent is to bring the building back into active use in a way that fits the scale and character of the neighborhood. Something very low impact, focused mainly on takeout sandwiches and Italian goods for local residents. I'm not installing any grills or fryers, only potentially a small turbo chef oven. and maybe a crock pot for meatballs or whatever. I'm also requesting a waiver of the grease trap. I don't know if that's something you guys deal with, but,
No, that would be the Board of Health.
okay. So I'm only requesting 4 seats inside, 2 small tables, designed intentionally small to match existing parking capacity and reduce traffic. My goal isn't to create a high-volume restaurant. It's to restore a vacant property, bring back a sense of community, and operate a clean, family-friendly neighborhood deli for Plymouth residents.
Thank you. Bring it to staff.
Thank you. So this is a special permit to allow a change of use from one pre-existing non-conforming use to another, and in addition to waive the required off-street parking spaces. We are recommending that the board consider a recommendation of the Zoning Board of Appeals that this be granted with conditions, finding that the proposed use is not substantially more detrimental to the neighborhood than the previous use. There is no hazard to pedestrians or vehicles or nuisance on the neighborhood. We do have a comment from our engineering department requesting a revised parking space layout plan, as the existing parking spaces have some encroachment on the town property and roadway layout. So we would recommend that prior to further permitting with the building department, that be addressed. In addition, documentation of water and sewer services on the plan. I would like to note that when it comes to parking for this pre-existing use, the previous retail use would have required 1 space for each 200 square feet for a total of 4.8 parking spaces, and the use demand for this is 3 spaces per seat. So that's a total of 2 parking spaces required, so this is a reduction in the overall demand of parking that would have been prior.
Okay, very good. Open it up for public comment. Is there anyone in the room wishing to be heard on this matter? Seeing no one, is there anyone on Zoom wishing to be heard on this matter?
If you'd like to be heard, raise your virtual hand. I'm not seeing a response.
Okay, I will bring it to the board. Mr. Grandy?
I have no questions. Thank you.
Thank you. Mr. Mann?
No questions, thank you.
Mr. Donaldson?
I have no questions also. Thank you.
Thank you. Mr. Bennett?
I do have a few questions for you. I like your idea. I think this is going to be a positive influence on the area. I think I'm coming down in your favor on the parking. I don't see how the parking spaces that are on the little half-moon shape of town property could be relocated without losing, it looks like 3 spaces. So I guess my comment's not necessarily for you, but I'm somewhat rebutting engineering's comment that those should be removed. They've been there for 45 years at least that I know of personally. So I think I wanted that in the record. And I do think, and I don't know if this is your responsibility or your potential landlord's responsibility, but that dumpster should be screened. It's just sort of sitting out in the parking lot there. And typically, a modern site plan would require screening, and I would like to request that perhaps the landlord put some fencing around it to screen it from public view.
Okay. Part of the reason why I want this particular location is a couple things. I actually grew up down the street, so I went there a lot as a kid, rode my bikes there. And also, like, the landlord is nice enough to kind of work with me on it, so the rent is not going to be super expensive. Quite frankly, I wouldn't do this anywhere else because of the cost of rent and stuff like that. So.
Yeah, I think that it might be to your benefit to have that dumpster screened off right outside your front door.
Okay.
Consider it. I don't think I'm going to make it a requirement of approval. And that's all my questions.
Thank you, Mr. Bennett. Everyone has already commented on the things that I would have looked at. Again, I'm in agreement. I don't think I think what you're proposing, the parking needs can be flexible. I read your submission, your story, basically how this was just a thought process that has now snowballed into a genuine proposal. And I just want to commend you on that. This is a big step for somebody. And this is a site that sorely could use a big step. So I want to tell you that from my perspective as a resident, I appreciate people stepping up and taking these underused spaces and trying to make them part of the community again. So thank you for your efforts on that.
Thank you.
And that's my comment on that. So anything else from members of the board? Seeing none, I will entertain a motion to recommend to the ZBA.
I'll make that motion.
I have a motion to recommend to the ZBA. Do I have a second, Mr. Donaldson?
Yes.
I have a second from Mr. Donaldson. Further discussion? Hearing none, I will call the roll. Mr. Donaldson?
Yes, and good luck.
Mr. Mann?
Yes.
Mr. Grandy?
Yes, and good luck with the Board of Health, because I think they're going to make you put in a grease trap, so.
Mr. Bennett?
Yes.
And myself, yes. Good luck with the ZBA. Good luck with all of the whole endeavor. Really appreciate your coming about.
Thank you. Appreciate it.
Next on our agenda tonight, we have ZBA 4191, 23 Aldrin Road. Joseph, and I am going to apologize for my inability to pronounce that name properly, so I'm going to leave that to you folks to do.
Yep.
This is a special permit required per 205-12 and use table category D27 to allow a personal service establishment use in the light industrial district.
Yes, good evening, how you doing?
Good evening.
How are you?
Good, thank you.
Good. My name is Joseph Yanuskewicz. I'm a lifelong resident of Plymouth. I'm prepared an opening statement, if you don't mind.
Go right ahead.
My wife and I are excited to bring a Thai massage practice to our community at 23 Aldrin Road, located in a former medical office within an industrial park. Because the space was previously used as a personal service establishment, it already has proper layout, parking, and accessibility to accommodate clients without creating additional strain on the area. The business will operate by appointment only, ensuring that customer traffic remains steady but limited and far below levels of larger businesses nearby, such as the gym or catering company. There will be no loud equipment, outdoor activity, or disruptive deliveries. In short, the practice is quiet, safe, and low impact. We believe this makes it a natural fit alongside existing businesses and a positive addition to the park. My wife there is a licensed massage therapist, trained at Spa Tech, and committed to offering safe therapeutic services. We are confident that this practice will enhance wellness in the community while respecting the character and needs of the surrounding businesses. Thank you for considering our application.
Thank you.
Thank you so much.
Bring it to staff.
Thank you. So per the use table, this is a special permit required for this use in the light industrial zoning district. We're recommending a favorable recommendation to the Zoning Board of Appeals with the conditions that, per the town engineering department's comments, the revised site plan to depict parking spaces for existing and proposed uses be addressed, as well as documentation to confirm compliance with ADA accessibility. Thank you.
Thank you. Open it up for public comment. Anyone in the room wishing to be heard on this? Seeing no one. Anybody on Zoom wishing to be heard?
If you'd like to be heard, raise your virtual hand. I am not seeing anyone looking to be recognized.
Okay, I will bring this back to the board then. Mr. Bennett.
I have no questions, Mr. Chairman.
Thank you. Mr. Grandy.
I have no questions this time, Mr. Chairman.
Thank you. Mr. Mann.
No questions either.
Thank you. Mr. Donaldson.
I also have no questions. Thank you.
Very good. My only question for staff, what was the parking issue that that town engineering wanted to address?
Documentation of parking for existing and proposed uses on the site plan.
So just as a site plan verification?
Correct.
Okay. Again, former medical office space, so this certainly makes perfect sense as to the next use. I can understand that. So I have no questions for you. I appreciate your submission.
Thank you, sir.
Anything further from members of the board?
Motion to recommend to the ZBA.
I have a motion.
With staff's recommendations.
I have a motion to recommend approval to the ZBA with staff recommendations. Do I have a second?
Second.
I have a second. Any discussion? Hearing none, I'll call the roll. Mr. Donaldson?
Yes.
Mr. Mann?
Yes.
Mr. Grandy?
Yes, and good luck.
Mr. Bennett?
Yes.
And myself, yes.
Thank you so
Good
much.
luck.
Thank you so much. I appreciate it. Thank you for your time. Appreciate it.
Next on our agenda this evening, we have a public hearing. The Plymouth Planning Board will hold a public hearing in the 1820 Courtroom, 26 Court Street, Plymouth, Massachusetts, on Wednesday, October 8th, 2025, at considerably after 7:05 p.m. to hear the petition of Teal Tree Farm Family Trust, Leslie E. Plimpton, trustee, for approval of Teal Tree Farm Family Trust, requesting a special permit under the Town of Plymouth zoning bylaw per section 207-2 for a rural residential development, RDD, to create 3 residential lots with 1 existing dwelling on the lot and 28.69 acres of open space, and a special permit for approval as a sending site for the transfer of development rights, TDRs, as per section 205-70, on property of the land situated on 240 Halfway Pond Road and Halfway Pond Road located in an RR zone shown on map 111 as Lot 4 and Lot 5D. The proposed project is shown on plans entitled Plan of Land dated July 18, 2025, and Preliminary Subdivision Plan for TDR app dated August 21, 2025, located at 240 Halfway Pond Road, parcel, and here we go, 111-000-004-000, 111-000-004-004E, 004F, 004G, 111-000-005-005E, 005F, 005G in the RR zoning district. The petitioner or his/her representative or any other person interested in desiring to be heard on this request should appear at the time and place designated. Good evening.
Good evening. Bill Shaw from Associated Engineers. I have with me this evening Peter Hale, the PLS and principal at Associated Engineers, and Les Plimpton, the owner of this property, and has been the owner of this property for nearly 50 years. The purpose of what we're doing is to create 3 5-acre lots, 1 2.5-acre lot, and 28 acres of open space. It's the first time I think I've been before the planning board with a special permit where we're not digging anything up, we're not putting any utilities in, we're not building anything. This is handled completely by the bylaw, and the idea of doing the 9 certificates for the transfer of development rights allows that open space to be even more restricted. And what we did is put together plans that showed that the density requirements are met. And of course, there's no remarkable topography out here. It's flat. It's Les has been there for quite some time. What I will do now is turn it over to Les Plimpton, and he will give you the history and what his intent is with these lots so that everybody understands where he's headed.
Yes, hello.
Good
I'm
evening,
Les
Mr. Plimpton.
My name's Les Plimpton. And the reason I'm here and have been working with Associated is because I already have a family trust put together, but I'm working on my will. I have been there since 1972 when I bought a little piece of land, and I've bought more over time, a few years afterwards, and built it up to a 47-acre Chapter 61 tree farm. I raised 4 daughters there. They're all married and live upstate New York. They all have their own homes. One's been married for 25 years, but and they all love the place, my youngest daughter wrote an essay for getting into Wheaton College, applying. And I asked her if I could read it. And her title was Growing Up on a Tree Farm. I'm in my 5th 10-year plan with Chapter 61. I just renewed it January of 2025. And so in my house that's on this proposed 2.5-acre piece, in the Chapter 61, the forest manager said, well, you can't have your house on tree farm. You can't grow trees through your house. So he had demarked an area around the house out to the street, the driveway, to designate where the tree farm is not. It never got a book or page or deed or anything, and I'm so glad I went to Associated to help me out with this. I have the 4 daughters. We intend not to do anything but I do want to leave them all a piece of land, 3 of these 5+ acre pieces, and then 3 of them would get the land to sit on it and hopefully never do anything with it. Maybe their children would want to live there, I don't know. But my intent is for that 28 acres, which abuts Wildflower Lane, which also has that, RRD thing where they have, I don't know, do you know how many acres it is over there?
This is almost the same, 28 acres.
So before that, there was 65 acres there, and I had my 45, and the deer love it there. It's nice the way it is, and I want to preserve that. And so my intent would be to try and have one lot for each daughter and one lot with the house on it where one of my daughters lives there with her family and myself. And so that is what we're applying for, what my request is, what my hope would be that you people would approve. And for me to tie up that land in perpetuity would please me. Thank you.
Thank you very much. Open it up to public comment. Oh, it's actually staff first.
Thank you. I'll just go through a few things. So first, I'll just start off. This is probably one of the lowest density RDDs we see. Typically, people try to maximize what they can do with these bylaws, and this one is very low. And just as we look here, just to orient you, this is Halfway Pond Road. If we're looking south, this is Wareham Road here. The 80 Makepeace property is down to the south. This is at 28 acres of now conservation-owned land that was created through the abutting RDD. And this is all land that used to be owned by 80 Makepeace that is now under a conservation restriction and owned by the Commonwealth as part, and again, this is in the Halfway Pond as you go north of Halfway Pond Road. So we have a significant amount of open space here, and this will be a nice add-on to the open space that's adjacent to it. And then if we ever looked farther out, there's even more as we get into the CR lands from 80 Makepeace. One of the things they gave us was this plan that showed that hypothetically they could build a single access road, and again, this is a simple plan, but that shows that in an RDD type of development that you could maximize development by creating 9 more lots on this property and still comply with the requirements of RDD and create 9 lots. And then this, I don't know why this is not showing full screen, but you have the plan. So what they're looking for is a special permit for the RDD to create the 3 additional lots. So they have 1 house on 1 lot, and this will be 3 additional lots as was stated. They're also looking for, as we looked at that hypothetical plan, certificates for a vote tonight for the board to issue 9 certificates of transfer of development rights. And again, these are larger lots on their own. Wrong mouse. These are larger lots on their own with in that 5-acre range for the for the 3 new lots and then a 2.6 acre lot for the one with the existing home. What will happen, and it's important to note that with the certificates, the certificate is a simple vote of this board. It does not do anything. It does not allow those units to be created anywhere. What would happen is in the future, when a property was identified as a possible, what we would call landing site, somebody would apply for a special permit and say, I've worked with this property owner, I want to take 1, 2, 9 of these certificates, increase the density of what I can do in my property with these certificates, and in return, this property is permanently protected open space. So again, the issuance of certificates themselves do nothing more than just say, yes, we recognize that you have the potential for 9 more lots here. We're going to give you those certificates, and at some future date, you can land those with a special permit from this board on another site. Conditions that we have built, I keep going to the wrong mouse. Conditions that we have built into this is that there's a condition that there'll be no, they waive their right to further subdivide, that a conservation restriction, an open space restriction will be placed on the site, that they need to bound all the open space so that when and if these properties abutting it are ever developed, we have bounding for those open space. So again, we recommend the issuance of the certificate. We recommend the issuance of the RDD. It's very low density, and again, I think it's a great alternative to what could happen on a property of this size in this location. Thank you.
Thank you. At this point, I'm going to open it up for public comment. Anyone in the room wishing to be heard?
I waited this long, I'm going to say something.
You go right ahead.
No.
Make sure, if you're going to say something, we want to hear it.
Okay. My name is Jane Morrow. Les surrounds our property on 3 sides. The 4th side is the street. We couldn't be happier. We got Red Brook dumped on us. We got Wildflower dumped on us. We got Pine Hills dumped on us down there in South Plymouth. We could not be happier, couldn't be happier with Les's proposal. So go for it. That's it.
Short and to the point.
Yeah.
Thank you very much. Anyone else wishing to be heard? Mr. Watkins.
Thank you, Mr. Chair. Hampton Watkins, Chair of the LUAC. The one question, Les is a good neighbor. We've known Les for between 15 and 20 years, and I support his intentions, and I really think that this is a great idea. I'd love to be able to pass on what I have to my child and grandchildren. The one question that I had, and this is probably directed to staff, but will the land use change? I know that there are carve-outs in Chapter 61, and the land is currently in Chapter 61. Will the land use change with this subdivision? And will that have any impact on the qualification under Chapter 61?
So I believe, and the applicant can agree or nod, but I agree, that's the reason why these are 5-acre lots. So at this point, I believe with the 5-acre minimum that complies with the Chapter 61 requirements, that these will stay in and would only come out at such time as somebody decides to build on them, correct?
Yes. Right, and there's also the familial exclusion for some of Chapter 61, and I say 61 generically, 61, 61A, 61B. So thank you for answering that question, and best of luck.
Thank you.
Thank you, Mr. Watkins. Anyone else wishing to be heard in the room? Anyone wishing to be heard on Zoom?
If you're looking to be heard, raise your virtual hand. I am not seeing that.
Okay. Seeing no further public comment, I'll have a motion to close public comment. I have a motion. Do I have a second?
Second?
Discussion? Hearing none, I'll call the roll. Mr. Donaldson?
Yes.
Mr. Mand?
Yes.
Mr. Grandy?
Yes.
Mr. Bennett?
Yes.
And myself, yes. Public comment is closed. At this time, bring it back to the board. Any questions from members of the board? Mr. Grandy?
No questions, Mr. Chairman.
Thank you. Mr. Mand?
Yes, I have some questions. First, I want to understand, is this 60 acres in total? What is the total acreage of all the property that we're discussing here?
My property, the total acreage is 47.
Oh, it's 47, okay,
Yeah.
thank you. And you're creating open space, or that's your intent of 28-point-something acres?
28.9, I think it is, yes.
The open space, or whatever that is determined to be, does it have public access right now?
No,
Is it
no more than the Wildflower Lane property adjacent to it. There is a road between Wildflower Lane property abutters. It's a survey road that Makepeace used to maintain to be able to get a truck down there, and that's the boundary line. And of their 65-acre piece, that the first time in 100 years, I think, Makepeace ever sold land, and they sold it to a developer. He put in Wildflower Lane and did his RRD thing.
So that the wildflower, you referred to the wildflower development there, open space, is that conservation land? Is that under any restriction, if you know? Or is
It's owned right now by the Conservation Commission of Plymouth.
Oh, it is by the Conservation
Yeah.
Commission of Plymouth, okay. So one of my, I don't know if I can express it as a concern, but one of my questions is, I think you could achieve what you want to achieve here in a different way without TDRs. I think you could designate the property as conservation, or you could, have Wildlands Trust take the property, many other ways, and I'm concerned that TDRs are an open-ended question. We don't know what's going to happen then. Normally, I think I'm not sure it's the practice, but I think it's the intent that a TDR has a sending site and a receiving site. So it's, in the case of Makepeace, we were preserving some priority habitat and some rare species, and in exchange for those sending sites, we allowed greater density in the areas that I'm sure you're aware of down Halfway Pond Road. In this case, there is no specific receiving site intended. Therefore, where and how these could be used is unclear, and I'm uncomfortable with that because I've already seen TDRs being used to create density that I wouldn't otherwise have wanted in particular areas. So what I would rather that you come up with there's a way that you could do this, that you could make this conservation property without the TDRs, and I think potentially they could create a problem down the road. For example, I wanted to ask Mr. Hartman, I queried Ms. Lynn earlier, but do we know how many outstanding TDRs there are right now?
So I was trying to get a number from 80 Makepeace, but they have between 200 and 250 TDR rights that will not fit on their project. Right. And then beyond that, I would say there's no more than 3 or 4 other TDRs that exist out there from other developments that have been issued certificates that haven't been landed. It could be as high as 10, but it's somewhere in that range.
Yeah. So it seems to me that there's almost a glut of TDRs, and so the potential is, and I think we've seen it, that they get sold to other entities that they're not as enlightened as you. They're not looking to preserve space. They're looking for just greater density in general. And I know, as Mr. Hartman advises, and I take it seriously, that we have the right to approve or deny those uses, but I think there's almost a kind of sense of obligation when somebody has those to err on that side. And I'd rather not. I'd rather, conservation land is conservation land, clearly designated such, public access if possible, CRs if possible, wildlands trusts or other entities owning them. And I think that's more protective of the community in the long run, and I know that's what you want to do. Let me ask you as well, is this, is your conservation land or your open space, is it priority habitat? Is it like in the, a lot of the land that Makepeace put in TDRs, is it?
I'm having a little trouble hearing you. I'm sorry.
Priority habitat, as determined by the state, that there are rare species on it, or is it the tree farm we're talking about essentially?
It's a tree farm.
And in that regard, is a tree farm a place where you actually cultivated trees, planted trees, or and what kind of trees?
Tree stand improvement, whatever my forest manager. It's a 19-page application.
Okay. What kind of trees are they? It's just what's
white pines. I have oak, scrub pine. It's I planted 4,000 plugs of Christmas trees against his wish. He said, finally, okay, you can do it less. But he said, fir trees, like a 4-month frost, you know, white spruce.
I just wanted to understand what kind of habitat or woodlands it was.
Well, there is some protected habitat area.
If you could put the screen up, please, again. So the priority habitat is this area right here. So it's the rear portion.
Oh, so it is the portion that is predominantly priority habitat, you're saying? Yeah. That's good to know. So yeah, I'd love to see this saved and improved. I love your ideas. As others have said, it's a rarity when an RDD or something that is used for preserving more space than developing. As your engineer said, there's no shovels going in the ground. All those are great things, and I'm in favor of that. I'm just concerned with what can be the unforeseen consequences of TDRs being used in ways, I can't even say inappropriately, in ways that I would rather not see. Anyway, thank you.
You're welcome.
Thank you. Mr. Donaldson?
I have no questions, Mr. Chair. Thank you.
Thank you. Mr. Bennett?
No questions, Your Honor.
Okay. I also applaud your approach to this. I have a bit more faith in the TDR system than Mr. Mand does. We have seen TDRs used for a very specific purpose, that being to create the opportunity for open space in exchange for development. You're actually proposing open space in exchange for more open space. You're literally creating lots to leave them as open space and asking for fewer TDRs than I think you could probably get away with if you really tried to work that out on that lot. The fact that we have a TDR system that needs some work is a different issue. Mr. Mand is correct in the sense that right now, the way our bylaw works, the landing sites for TDRs, not in the places that TDRs should be used. They should be used where we have infrastructure, not in our rural areas. But that's not the issue for you today. You are following our bylaw. You're creating open space. You are doing something that your neighbors fully support. And I see no reason to punish you because we didn't draft a good bylaw. At the same time, I also am not concerned that there's going to be a run on TDRs, given that, A, this board makes the determination as to where those landing sites are and what types of projects are appropriate. The number of TDRs that have been used in the last decade is outside of Red Brook is almost non-existent. It's a fraction of the percentage available. So we're not seeing people rushing to build high-density developments in areas that we don't want them. And so I fully support your efforts, and I thank you for your approach to this.
Thank you.
Anything further? Mr. Bennett?
No, nothing further.
All right, anyone wish to make a motion then?
Motion to approve.
All right, I have a motion from Mr. Donaldson to approve, and I'm going to take that as a motion to approve the entire request, both the RDD and the TDR request.
With the conditions.
With the conditions as
With the
set.
conditions.
And just to point out, it's a quantum of vote of 4 members.
Okay?
Second.
Second from Mr. Bennett. Further discussion? Hearing none, I'll call the roll. Mr. Donaldson?
Yes.
Mr. Mand?
Yes.
Mr. Grandy?
Yes.
Mr. Bennett?
Yes.
Myself, yes. Thank
Thank
you
you.
very much.
Thank you, the board.
Thanks for your time.
Last item on our agenda this evening, we have the Earth Removal Bylaw Committee charge. Before the board is a proposed charge for the Earth Removal Bylaw Committee that has been discussed over the last several weeks. This charge is the sum of discussions with the Select Board, the COPC, and the representative of the Plymouth Stewardship Alliance, which sponsored the earth removal moratorium and agreed to withdraw that moratorium request, no motion, no action before FinCom, in exchange for our support in creating a committee. This committee, just so the board members know, this was the scope that was presented by myself and the PSA representative, Love Albrecht Howard, to Precinct 17 just a week or so ago. So this was that. There were a few changes made following last night's Select Board meeting to address a few things. So those changes were to address the fact that the committee will work in tandem with the consulting team retained by the town. Just to stress, one of the biggest concerns that we have from an operational standpoint is staffing. As has been somewhat announced around town, Mr. Hartman will be leaving us this year, December 5th. I believe it's his last day. He will be going to his well-deserved retirement. We will miss him immensely. We will be, however, ably supported by Lauren Lind, who has been appointed to take his place, and that is good news for us as we are welcoming her in her new role. That said, we will be short-staffed for a period of time. Ms. Lind needs to hire a replacement for herself. We have other retirements that have taken place, another one that will be taking place. We've had some medical leaves as well, and we were short-staffed before that. So this committee will be appointed per whatever parameters we set tonight, and their role will be, to some degree, to create the scope for and then ultimately select the consulting team. Now, in terms of funding that, we have Mr. DiNardo, I've noticed, present this evening, and Mr. DiNardo has announced an intention at town meeting to seek to amend Article 1 to call for an appropriation of $75,000 to hire the committee, to hire the consultant, so that the consultant can be engaged as soon as is reasonably practical. I believe is it January 1 that funds become available after appointed at town meeting, or?
15 days.
15 days, okay. So after the committee gets appointed, there will be funds available. They can then work with consultants to create a scope and then do an RFP, and the committee itself will be ones responsible for choosing the consulting team that is going to help them in their drafting and other guidance. So the scope of this committee, again, these were things that were discussed by the various bodies that I referenced. So I'm going to just go through them quickly to talk about why we created, what is being proposed is being proposed. So again, this is an earth removal bylaw committee to explore potential changes to the town's earth removal bylaw. The goal is to identify better ways to better protect our environment while supporting economic development. That was the stated intent of the PSA in a number of their initial publications, and that was something that they asked us to specifically include. Committee will be making recommendations to the planning board for adoption by town meeting. That is the charge of this planning board per town charter. Somebody has to create the committee. Because this is a bylaw change, the committee, that falls under our jurisdiction. The activities are listed. Again, these are just some of them, but this is the scope of the committee. This is what they're going to do. They're going to be looking at our bylaws. They're going to be looking at our activities here in town, and they're going to be looking for recommendations. They're going to be making suggestions. So it's an advisory committee to the planning board operating under our rules and procedures. It will work with the consulting team retained by the town. Committee will be disbanded after recommended bylaw changes are presented to this planning board and to town meeting. So once the committee has made its recommendations, it will be disbanded. It's not an ongoing committee. That's the purpose of this committee, so it's a single-purpose committee. Committee will consist of 9 members, appointed 3 by this board, 3 by the select board, and 3 by the COPC. That was a proposal that came from the select board, specifically from Mr. Cohan. The COPC was in favor of that, so I would encourage this board to also be in favor. The membership criteria. This was something that was specifically discussed with the PSA because this is to be more of a technical advisory committee than other committees that we've created in the past. What we have seen just tonight is what happens when people try and create things based on what they would like to have happen, but not follow the technical requirements associated with that. Our goal is to have a bylaw proposal that works for this town, that can meet the requirements of the State Attorney General and any legal challenges. That's one of the reasons that the consulting team specifically has been asked to include legal and legislative assistance to the committee. So for that reason, we were looking to create broad community representation in the committee through memberships of Plymouth residents. Again, this is something that is important to Plymouth. It's Plymouth specific. Other towns can do what other towns wish to do, and we can certainly coordinate with other towns, and they can look at what other towns do, but that doesn't mean that we follow them. Plymouth has its own specific needs, so we want Plymouth residents to do that. We've asked that no elected officials be on this. Again, the goal here is to have people who don't otherwise have a forum to express their opinions and an opportunity to participate. We're also looking again to try and make this a more technical committee. So again, we're looking for preference for people with geotechnical science, engineering, legal, legislative, and we've added climate science, public health, and hydrology. And again, I'll just note for the record, hydrology is a geoscience. But ultimately, it is in essence people who understand or have some measure of understanding as to the science behind this and how to legislate for it. Again, so that we can create scientifically supported legislation that will meet our needs and get approval by the state. And again, we have a preference to select only one member per various organizations, advocacy groups, businesses, boards, etc. Again, the goal being to give voice to people who may not normally get a voice. The goal is to, again, say, look, we have people who are interested in this. We have people who have experience in this. They may not necessarily have the same types of experience with other boards and committees that people do. We want to hear from them this time. We want to broaden the participation. So that's the reasoning for this. And again, all of these terms were created by agreement with the various groups who had input. So I now open it up to our committee to discuss this, and I'll start with Mr. Mand.
Thank you. So some of this is very new. We only got the original charge the other day, and then before the meeting, this modified version. So I was going over it as you spoke and looking at some areas that I'd like to see potentially language change or maybe even additional expertise areas. One of the things is that, yes, the PSA and other community people talked about this potential legal change in terms of better ways to protect the environment from earth removal in general terms. But I think that in the charge that we might be more give more emphasis to the environment we want to protect, because it's not generic. It's in this town, it's our unique environment. So I'd like to see potentially add our unique environment to that opening purpose. Then in the next section, Activities Committee will include, I would like to add may include but are not limited to the criteria or the committee.
So if I could just interrupt real quickly, we will have to go through this whole process and put everything on hold. The goal was to start to advertise for the position. We talked about this with Committee of Precinct Chairs and with the Select Board, so just understand if we're going to make that many changes, we're going to have to put the brakes on this and go back through and get back before these boards with these revisions. So just, again, as we talk about...
So everyone is going to use the exact same charge?
Yes. This is your committee. These people are making appointments, but I think if there are significant changes to what you have tonight, we need to go back to these other groups and advise them of these changes, and they may want to make more changes based on that too. So just understand where we are right now. So I don't want to have somebody say that we're trying to stall this, but this will hold this up because we'll have to go back to the Select Board and report back to them to these changes.
To answer your question, Mr. Mand, yes, everybody, the charge comes from us. It is our committee. We're asking others to appoint based upon our charge, but the charge comes from us. That said, we tried to create a charge with everybody's input so as not to be dictatorial.
Yeah, the discussion that I heard at the COPC was that they were going to have their charge would have been different. That's what they said at their meeting. But I can see
I've been in contact.
I can see that I understand what you're saying. And
we've been in contact with them, both myself and the chair, and they have a copy of what you have before you now. And that's what they'll be working off of. And the selectmen, again, this is with the red lines that you see are the selectmen's requested changes. And again, I'm not saying you shouldn't do that. I'm just saying that this will have to go back through the process, and we'll have to meet again with the Select Board.
Yes, one of the things that I think everyone, or at least the community wants, is to expedite this in any way possible. So I don't want to impede this.
Bless you.
Let's see. Like, one of the things I'm concerned of is that the limits on...
So my suggestion, again, especially at this late hour, is maybe you can type those up. We can put this on our next agenda, and we can have the changes you want and we can consider that, and I'll tell the selectmen and the administrator up there to hold off on the appointments. We can then look at the changes you want versus trying to just do it on the fly like this.
But we are advertising 30 days, correct?
Well, I think we have to put it on hold if we want to
Well, I'm
we
one
need to have
member.
the charge.
Frank, do you want to make changes to this document or not? Yes or no?
I would like to make changes, but I don't want, I'm weighing in my mind whether or not the importance of a delay versus some of the things I'm concerned about, and that's why I was going over this. I mean, I didn't have a chance. Did you have a chance, Mr. Grandy, to review this ahead of time?
No, it was handed to me this evening.
So again, that's my suggestion. We can put it on, what's our next agenda?
October 22nd.
October 22nd. And then any changes any board member wants to make can make those, and then we have a discussion. I'd be nervous about advertising the positions, though, without having the charge.
No, you need,
finalized.
if I may, Mr. Chairman, I think it's important to have a charge in place before you start appointing people to
And
this.
Frank, I do apologize. I feel like I'm putting you
No,
on the
I-
spot, but I'm just
Well,
want to
do it right.
explain the logistics.
No, this is the spot I'm in. You didn't put me here.
Okay.
The spot we're in to some degree was the fact that we had to negotiate with multiple groups, and this is not one person dictating this. This is not something that I drafted, Mr. Hartman drafted, or then just said, this was vetted through various other groups. Obviously, I wasn't going to vet it through this board. That would be a violation of the open meeting laws. So this was done as collaboratively as possible to make sure that other bodies would not object when we presented it.
And what we've heard loud and clear is the urgency to move forward. So that's why we've tried to expedite this as fast as possible.
In fact, it was you who insisted that we put it on the agenda tonight, and that's why it's here. And that's why it was done as quickly as it was.
Frank, I'm feeling really guilty. I really am.
No, I would
Again,
continue it to the next meeting and give the
it's-
opportunity to put your suggestions in there as far as the language. But then again, Mr. Mann, it's going to have to go back to the Board of Selectmen and the COPC.
Yeah, and they would
And
all
everybody else, too.
They would all potentially have the same delays, which push them back.
Oh,
So,
they'll certainly have that delay.
so I'm going to blame Mr. Hartman and say, yeah, let's move forward.
So I
In the
jokingly
interest of time.
I jokingly said to Lauren that maybe we need a committee to talk about the committee.
Yeah, I'd love to be able to go home here.
No further comment.
It's almost 10 o'clock.
Motion we'd be looking for is to adopt the charge as amended and to go ahead and authorize us to seek the applicants for the positions.
So we would authorize you to seek the applicants and to, so again, let's be clear, the way this is going to be done is that each of the three appointing bodies will do their own appointments. So applicants will apply, they can apply to one particular appointee or all three appointees if they wish, and get appointed and go from there. But each body will appoint three. So they will each have their own, they will each follow this criteria, but they will do their own appointments.
And we communicate with the other people, so if there are, whoever goes first, I've said, and there are extra applicants, we can always add that to the pool of applicants, to the other two boards, and then, you know, as we go through the process.
Absolutely. The goal, again, being to get as broad a committee as we can and to get new bodies in there with new sets of experiences.
May I make a motion?
You absolutely may make a motion.
Motion to support the Earth Removal Bylaw Committee charge as amended here this evening.
Okay.
I have a motion, I have a second. Any further discussion? Hearing none, I shall call the roll. Mr. Donaldson?
Yes.
Mr. Mann?
Yes.
Mr. Grandy?
Yes.
Mr. Bennett?
Yes.
Myself, yes.
And now may I make another motion?
You most certainly may.
Motion to adjourn.
Second.
All in favor?
Aye.
Aye.
This meeting is adjourned.
Recording stopped.